First opportunity to contribute this year, so can I offer a New Year greeting to all colleagues, and particularly as it's the Lunar New Year for the Year of the Fire Monkey. Gong he fat choi, shin yin kui le. Mr Speaker, this is a very important bill, as the member who's just presumed to speak, Mr Bailey, has quite correctly pointed out, and I'm passionate about IP for exactly the reason that Mr Bailey has specified. We stand on the brink of what is called the second information revolution, and the Labour Party's been thinking a great deal about the impact of that revolution on the future of work, the importance of having a resilient economy, a well-trained workforce, and to add value through productivity that lifts incomes and provides a good life for all New Zealanders. And that's absolutely crucial, that we get away from just thinking of ourselves as, while it's not bad in itself, it's a good first base, producers of world-class commodities and agricultural products. We must add value to that, and the number one way to do it is by adding information, and protecting that sustainable competitive advantage requires intellectual property rights. And this bill tweaks, doesn't radically change, but it tweaks the system through which they are awarded and maintained. So what I'd like to do is divide my remarks into three sections: a quick touch base on the principles that drive this reform, a quick summary of the provisions and some issues that the Select Committee may wish to consider, and then a word at the end on the process as we sum up. So the principles are that whatever we do in the area of intellectual property and patents must serve a higher order goal, the strategy of building a high-value, information-rich, highly productive economy in a very dynamic and rapidly changing world. So this bill's got to play a small but positive part in that process. Drop it down a level, and from the point of view of the individual company, and we're a nation of small businesses where 80% of our companies employ less than 20 people, we've got to reduce the costs to Kiwi companies of getting a patent. We've got to make it easier, and we've got to make it more effective. So that's the number 2 test. And number 3 test is we've got to make those patents more effective. They've got to be easier, not harder to enforce, certainly across the Tasman and globally if we can get it. So how do the provisions shake up against those tests? Well, sir, the first provision, the key one, is the amendment of grounds, and that is the removal of the opportunity for third parties, that is not the company, say the New Zealand company taking out the patent, but as my colleague Ms Curran said, the possibility of offshore patent trolls, removing the possibility that they can make an objection based on the fact that a singly accepted patent application applies to more than one invention. That is called the lack of unity of invention objection. It is often used in defensive patent objections and filings by patent trolls. And it was very sobering to hear the stats from Claire Curran. About 2/3 of all patent activity in the United States is defensive or trolling patents. And I've heard from a very senior patent attorney in New Zealand that around 90% of all patent activity in New Zealand is defensive patenting by international companies, and only 10% is by New Zealand companies seeking to acquire intellectual property rights of their own. We have to turn that around. We have to get that balance better, and that is a key objective. So as this goes to the Select Committee, at first blush, the removal of that trolling provision looks like a very good idea, but let's get the Select Committee to test through the submission process how that's going to work in practice. Sir, the second major provision is the Single Australia and New Zealand, or Trans-Tasman, patent protection process. It has 2 component parts, both of which are voluntary, under the framework called the Single Economic Market process that was agreed between Kevin Rudd and John Key on behalf of our 2 countries several years ago. The first is the Single Application Process, or SAP, and the second is the Single Patent Examination, or SEP. And that creates a single portal, an online patent application process where a company applies only once, and it feeds through to apply to both jurisdictions, IPONS in New Zealand and IP Australia across the ditch. There is a single examiner who works through the evidence and awards or doesn't award a patent that applies to both countries. That's really important. Potentially it saves cost, it saves time, it saves duplication, but if we look through the lens that around 4 times as many patent attorneys reside in Australia as New Zealand, and the fact that the average size of a Kiwi company is much smaller than the average size of an Australian company, we have to ensure in the fine print and how this will work that it suits New Zealand companies, because that's who we're elected to represent. And so we just want to make sure in detail that this is a step in the right direction. There are some issues the Select Committee can look at in that regard, sir. The first is in RIS number 4, where it says that the costs have not yet been quantified, and goes so far as to say we don't know whether the cost of filing is going to go up or down. It should go down because there should be efficiency gains, and the value should go up because it applies to both countries. But it would be great to get some evidence from officials on whether that will in fact be the case, because we get paid for our results, not our good intentions. Secondly, sir, the scale issues are really important and not least in the TPP context. Sir, I know that's a slight side issue, but there was relevant debate earlier around the application of patents to software, where around 94% of the ICT industry surveyed said, sir, that they did not want patents to apply to software, and I believe the government took some heed of that. That's crucial because it shows that in the heart of the information revolution, the patent system, which was designed for the industrial age, doesn't work so well in the information age. And sir, as part of the Commerce Select Committee now, I want to make sure that this and other IP legislation is future-proofed to take account of that second information revolution. There's some wonderful quotes by Ian Taylor, the president of the largest IT representative body, the Institute of IT Professionals of New Zealand, and of course the CEO of Dunedin firm Animation Research. He says, we're an export-driven sector, so we love free trade. However, this can't come at the cost of the future of the technology industry. And that's what it will be if New Zealand's current law banning software patents is traded away in the TPP. And so I think that's a very interesting little vignette. It's a side issue to this bill, but it goes to the heart of why we need to take a very careful look also at the TPP, and goes to the reasons why Labor opposes it. So the third key provision is the joint Australia-New Zealand registration of patent attorneys. There are about 200 in New Zealand, about 800 in Australia. They're going to have a single representative body with a single registration process and a single disciplinary regime, and those clever patent attorneys also tighten up the loophole. You will not be able to provide patent attorney services at all unless you're registered through that joint Trans-Tasman body, which of course will ensure both minimum standards and no doubt minimum costs. Sir, the governance regime is a key issue the Select Committee is going to have to look at in that regard. What do we mean by that? Well, who runs this thing? And why? What rules will it be run? And given that there is a little bit of a difference or a disequilibrium between the average Aussie IP-rich firm and the average Kiwi firm, we're smaller, we're more nimble, we need to ensure that the rules suit those Kiwi companies. We need to have a governance system that allows us to go and bat for our own. And if it doesn't, then we may see the benefits of this trade-creating measure occur disproportionately to the other side of the ditch, and that wouldn't be our primary objective. So we need to have a good relative level of influence based on a very important constitutional principle, which is called sovereign equality. We are a sovereign state, Australia's a sovereign state, the rules have got to be equally fair to both. We are not a state of Australia, we never will be, and the Select Committee will have to ensure that the fine print of these governance provisions reflect the principle of sovereign equality. So doing, we protect the interests of New Zealand businesses. Sir, I've done a quick romp through the principle, the provisions and the process. The process simply is that the Select Committee needs the time and the due diligence to make sure we hear from the industry. Hope we'll hear from the tech sector, from the patent attorneys, from the lawyers, and we'll work through the detail from there. Labour supports this bill at first reading. Thank you.